Good afternoon. Thank you, Nancy. We've heard a lot today. We've been alluding a lot to questions about terminated or swapped. And understand a little bit more on state. I've heard people saying charitable. I really want you to walk away from this. Nonprofit charities, and directors of nonprofit charities and the managers, the high managers that have general fiduciary duties to the organization that are very relevant when we talk about. I don't want to be missed. So that's what I'll emphasize. What requirements the state. Talk a little bit about how the nonprofit is structurally, there are structural deficits that may lead some good people to make points in this area, and then link up to general is so important. Okay, so take one of our examples we're talking about all day. That land, my PowerPoint slides are not nearly these, but I'm trying. We have our land with the conservation easement, and then develop land, and you see the act there. Suppose that donor the land. Only problem is it would be much easier for that developer. I'm calling of land free from the easement. I realize when I say that's 1 acre, that makes that tree really, really big. So, play along. All right. He wants to buy that. He of the land who approaches already holding the right to force the easement, and the developer says, "I'll give you land in exchange." So, no problem. Right? A lot of charitable boards might be just simply go ahead with this. Why? Well, for one thing, they want to continue to have a good relationship with the owner of the easement they own is still subject to it, and they want to have a nice working relationship. This may be a community where they know the developer. They're behind the project. They don't see any reason why the developer shouldn't be helped out a little bit. They swap here as their organization. So it looks like a win-win deal. Okay. First, important to is that the charity's right to enforce easement must be construed as a property interest under state law. It means the charity that it owns, investments, anything else. And that means when it's determining how to manage or handle that right, it is bound by, it has fiduciary duties under steps before making. So I want to, the fiduciary duty, later, duty of obedience to nonprofit board. Can they simply look at this deal and say, it looks good to us, and go ahead? Well, the answer is no. The new service, if they get of this, and it's only been 2 years since the deduction was taken, may know that this causes the deduction that was taken by the donor valid. So that's going to be a problem. The problem with this act, if the service gets involved, is the impact that it's going to have of sudden things that the charity will, and it's something that we should be careful of. This is, I think, exemplified in the Myrtle Grove controversy that you brought up. Fallout. I thought it was best. You also know that it looks like under this charity simply can't swap. We've heard today that this charity has to, in fact, can only lift the easement from that triangle if they can establish to a court satisfaction that restriction is impossible or impracticable. Now, if that is in fact the law, failure to if the Attorney General in the state gets involved, worst case scenario, the directors who made that determination could face personal liability if that decision ended up damaging the corporation. But best case scenario, when the attorney is involved, the nonprofit is spending money. They are spending money defending their assets that have been promised to be directed toward the accomplishment. So it's something you have to take care of. Now, something else that's been brought, suppose for some reason charitable trust doctrine doesn't apply here. Suppose it's not a restricted gift. Suppose do other things to abide by their duty. So what? They should only be engaging in this transaction if they can be sure. So should take time to ask questions about the value of the land that is being exchanged. They can't simply assume it's a good deal. They have to know it's a good deal. How do they know that from an ecological perspective that the land is, that preserving the new land with the same objectives as preserving the old land did? You know, you remember the first triangle was by pond. Suppose part of the objective was to protect swamplands, this very visible environment. Swapping that out, that swampland land does purposes. These kinds of things, failure to consider this and make sure that the swap furthers charitable objectives could be a breach of the duty of care under state law. Now, there's always also another critical fiduciary duty under state law, loyalty. And this is something I've written a lot about because I think often people don't realize, really well-meaning people running charities don't realize that they may be violating the duty of loyalty. What is the duty of loyalty? It is the promise and requirement that the fiduciary will place the best interests of the charity ahead of self-interest, ahead of the board member or executive director's personal interests. What kinds of things could be going on here that could start to play with the duty of loyalty, might start to violate it? Well, suppose a couple of people on the board have invested in the shopping center development. And, it's good for them, right? They think, well, this doesn't hurt the charity, helps me, why not? That's a conflict of interest. It's a bad conflict of interest. Suppose some of the people on the board have also donated land nearby, and they know that this developer or another one has approached them to release their easement, their right to enforce the easement. Might they be agreeing to this simply to make sure that it paves the way for their own release later? Something that must be brought forward and discussed. Sometimes the conflict is even more amorphous. The real estate developer is well known to everybody in the town, and the board members, one or two, might want to curry favor with that developer for other reasons. Have nothing to do with this, but might have a lot to do with other business opportunities. There are conflicts that are required under state law to be brought up, fully disclosed, and rigorously debated to ensure that the nonprofit does not go forward with this deal unless they are positive and can prove to themselves that this deal is clearly advancing the charity's best interest. Now, and I don't think I have time to go in, yeah, well, maybe I do a little. Okay, the conflict of interest point is also important from the perspective of the Internal Revenue Service. If the Internal Revenue Service determined that the swap issue aside, that this deal actually gave a private benefit to one of these directors, they could face, your organization could face, of course, penalties, and in the most extreme case, if this was something you were doing on a regular basis, the loss of your 501c3 exemption. So if nonprofit directors are going ahead blindly, not digging out conflicts of interest, not dealing with them responsibly, you are endangering your charity on two fronts. One, exposing it unnecessarily to potential legal liability, and at the very least, requiring it to vote resources to argue their point. And two, you're damaging your nonprofit in the court of public opinion. And as we know, there's nothing that chills donations and goodwill more quickly than scandal about whether they're self-dealing in a nonprofit. Okay. So, notwithstanding all of these very serious concerns, good people in the position of the directors of this board might go ahead with this transaction without engaging in any of those steps. And why is that? I'm going to argue that there's structural defects in the nonprofit form that make it quite easy for good people to make bad decisions. So what are they? The first thing it's important to realize is there is a relative lack of monitoring of nonprofit fiduciary behavior, okay? And it's very hard to tell if a nonprofit board is effective at accomplishing its mission. So just by way of contrast, I'm going to skip that slide. There we are. By way of contrast, here one, what is their mission? Everybody knows what it is. For better or worse, it's to increase shareholder value. A clearly defined objective. Now, what monitoring mechanisms are in place to ensure that the directors accomplish their objective? Lots of them. Here you see that shareholders are principal monitors of the for-profit fiduciaries' activities. Now, individual shareholders may not monitor so much, but large institutional shareholders do a lot of work. There are secondary information markets, and all of this information that comes out about the performance of the company directly impacts stock price. And when share price goes down, indication that all is not well. Because why? We know what the bottom line is. Are they making money or not? And we can tell that if they're losing share price, they're not making money. So there's a lot of controls here. Another control, of course, is the market for corporate control. If the fiduciaries in the for-profit context don't do their job and they have an undervalued company, they may become a target of a takeover, and they don't want that. So that creates an additive incentive for them to make sure they meet the objectives that they're required to meet. Now, if you turn to the charitable nonprofit, you see a almost complete lack of monitoring. By definition, there cannot be shareholders because the nonprofit is an entity, not distribute profits to owners. So we know there are no shareholders. We know that the nonprofit fiduciaries owe their duty to the public. But the public, you or me or any individual person, generally has no standing to make them honor their fiduciary duties, right? The exception I have in light blue, here it is, down up there, is that if you have a nonprofit that routinely depends on repeating grants from foundations or government, there might be some monitoring going on there where they want to see exactly how the money is spent. But that's narrowly targeted monitoring. Basically, good. And my other point, performance of what? Right? In the for-profit context, we know, are you making money? In the nonprofit context, how do I tell if someone's making the best decisions possible to protect the environment or to make sure that important compared to what? How do I know what choices are made? It's very amorphous. So basically, monitoring is left to the Attorney General, who is public. And we know that constraints on AG's offices vary, but in some states, it's just not going to be possible for the Attorney General's office to devote enough resources to monitoring profit holding a conservation easement makes. And so we have this kind of situation where a board, and again, it is so important to me that you understand I am not suggesting that boards are badly intentioned. I think almost everyone that I have met in the nonprofit scenario, except people that create sham nonprofits, but everybody else is well-intentioned. They are altruists. The problem is when you're sitting in a room and you know that there's really not meaningful oversight of your decision, combined with a couple other factors to explain, bad things happen. So like what perception that people have when they're on the board of a nonprofit. Unlike the for-profit context, a lot of nonprofit directors don't see their role as monitoring the business of the nonprofit. They are often recruited because they're good fundraisers, because they know a lot of people, because they care passionately about the mission. But they don't view themselves as a watchdog, right? They view themselves as they help the executive director accomplish their mission. Second, they're usually volunteers. So think about the constraints on their time. I know myself when I serve on boards. There are nights when I think after I'm done with my day and my kids need stuff and they tell me they need white shoes for the play the next day and I didn't get them, that I'm supposed to read for a meeting, right? I've gotten this thing of documents and I'm supposed to read for a meeting. And it's sometimes very difficult for board members to be thoroughly informed about a particular issue when it's time to vote, no matter how well-intentioned. Okay. Finally, there's some research that shows that for many people, participation on boards, I would include for boards in this analysis, participation on boards creates a part of their social identity, right? Being a member of that board becomes part of how they define themselves. And they want to continue to be a member of that board. It makes them feel good. What's the problem? If in certain circumstances you get a room full of people with no time, limited information, good intentions, who don't want to rock the boat because we all get along, you might get something called groupthink going on. And so studies start to show that groupthink occurs when group members in the room value getting along and cohesion and feeling good about their decision more than they value having a rigorous debate or a process that emphasizes rigorous debate and analysis. So, okay, so I'm out of time, so let me, so I think that's really, I think I can cut there. That is a reason. We have a problem. We have well-intentioned people that might begin to think as a group, might not take the necessary steps, and without even meaning to, may find themselves of enforcement agencies at various times, at various points, and that causes damage to the nonprofit.